presentation in about 30 seconds. We're still waiting for some last-minute attendees to join the webinar, so just stand by. Welcome. Today, David Kaminski, an attorney specializing in TCPA laws, will provide a review of changes in the interpretation of consent and dialers under the TCPA. Please note that due to the high volume of guests joining this call, everyone on the bridge has been muted. If you have a question for David, please post it via the chat box located on your GoToMeeting client. David will do his best to answer all of your questions during his presentation. My name is Tom Moore, and I am with Avtex. It is my pleasure to be your host for today's webinar. Avtex's mission is to use our technology know-how to enable our clients to deliver an exceptional experience to their customers. Our area of expertise, what we call the Avtex 360, is focused on portals, unified communications, contact centers, and CRM. Before I introduce David Kaminski, I would like to acknowledge our partners who have sponsored today's event, Interactive Intelligence and Contact Center Compliance. Interactive Intelligence is one of the fastest growing companies providing contact center solutions. Their Customer Interaction Center solution is an all-in-one application providing multi-channel functionality to tens of thousands of users worldwide. With the recent release of their TCPA application, which can be incorporated with their CIC solution, Interactive Intelligence continues to work towards aiding contact centers to stay compliant. Lastly, I would also like to welcome Ryan Thurman, who is Director of Sales and Marketing with Contact Center Compliance and was kind enough to bring us David Kaminski. With more than 50 years of experience, Contact Center Compliance offers an array of software-as-a-service compliance products that help both contact and collection centers reduce the complexity of complying with federal and state dialing laws. Welcome, Ryan, and thank you again for joining us. With that, let me introduce David Kaminski. David is a partner at the law firm of Carlson & Macer, a Los Angeles-based civil litigation defense firm. He represents collection agencies and creditors throughout the United States in the defense of consumer, individual, and class action claims brought under the FDCPA, the TCPA, the FCRA, and related state and federal claims. He also serves as outside compliance counsel to numerous companies and has developed policies, procedures, and compliance training programs to minimize the risk of liabilities for the credit and debt collection industry. Thank you, David, for joining us, and please proceed with your presentation.
Thank you so much for that introduction. Tom, Ryan, thanks so much.
Thanks for joining us, David.
Everybody, well, thank you. I know this was originally slated as a 1.5-hour presentation, and that's what it should be. Unfortunately, I had an irreconcilable conflict with a court matter that I have a hard stop just at about 9:58 a.m. We're going to try to get through the entire materials. We're going to try to leave a little time for questions, and we'll also try to accommodate your questions even after this session by submitting your questions if we need to. Of course, maybe future presentations of this, if I'm invited again, will be 1.5 hours, and we'll be able to better accommodate. So thanks to all of you for bearing with me on this one. We're going to move at a fairly quick clip. Ryan, you can advance the slides.
Good.
Okay. So with regard to the agenda today, again, we're going to talk about the TCPA, the law, the FCC's role, and that critical FCC 2008 order, which seems to be constantly haunting all of us. I think we're going to get into express consent, we're going to get into dialers, and we're going to talk about compliance strategies. We're going to basically hit the real heart of the TCPA and what we need to speak about. Next. So just a quick brief overview. Next. And I think you should be concentrating at the screen on your left because that'll be the bigger screen. Ryan, go to page 4, please. Thank you. So the TCPA, very quickly. In short, the TCPA prohibits calls, made with an automatic telephone dialing system to a cell phone or wireless device without prior express consent or to leave a pre-recorded message. Again, it's a call via an automatic telephone dialing system or a pre-recorded message to a cell phone or wireless device without prior express consent. That's what we call the B1A section of the Telephone Consumer Protection Act, the wireless line or the dialer bands. Next, there's also the landline restriction with regard to the TCPA, and the landline restriction basically says this: you're prohibited from leaving a pre-recorded message on a landline without prior express consent. That's the difference between cell phones and landlines. Cell phones, if you use the dialer to make the call to the cell phone, or if you leave a pre-recorded message, you have potential liability if you don't have prior express consent. On the landline side, it is only potential liability for the leaving of a pre-recorded message. So technically, you could use your dialers all day, make calls to residential lines via your dialers, no potential liability under this prong of the statute. Call forwarding does not subject you to potential liability. Case law has talked about that, the FCC has talked about that when you forward a landline number to a cell phone. I'm not talking about porting, meaning changing it permanently. I'm talking about just forwarding it for the day or the week or whatever to a cell phone. You don't create cell phone liability. Next, the damages under the TCPA, I think you all know, you've heard about it, they're extraordinary. It's $500 per call for a negligent, what we call a negligent violation, and then you have up to $1,500 per call for what is called a willful violation, 3 times the violation. It's $1,500. And in some cases, we've seen that the potential liability has exceeded at times the $4 billion Chrysler bailout. And I know that sounds insane, but that's the insanity of this statute. And that's what I portray to judges, that when my client's potential liability for a 30-person collection firm is potentially, if you look at it in the extreme, $4 billion. I had a case like that in a class action. That's where this statute resonates to judges, that this is absurd, and they realize that we need a fix. They realize that the industries are in need for a desperate fix. Next, FCC, as you know, is relegated with the task of implementing the regulations under the TCPA, and they've done so. They've done some good and they've done some bad, and we all know that. On the landline side, as you can see here, they've given an exemption for commercial calls. So if you're calling a landline basically and you're making a commercial call, that call does not have an unsolicited advertisement. And basically the courts are saying that is a call that is then exempt under the TCPA. So again, if you're leaving a pre-recorded message on a landline, even if you don't have consent, that is considered to be a call that is exempt because it falls under the commercial call exemption, and the FCC has said for years, they've repeated again in 2008, that, look, debt collection calls to residents, they're not telephone solicitations, they don't constitute telemarketing. Why they didn't say that on the landlines, on the cell phone side, is anyone's guess. Next, there's some very good case laws that have interpreted the exemptions for leaving pre-recorded message on the landline side. And I'm just going to go through this very briefly because it's very powerful. Most courts all agree, the majority of courts agree, that if you make a pre-recorded message to a landline, you're probably likely to fall under the exemption. And if you see this Hoover case at the bottom of the screen, that Hoover case, and citing Franasiak, goes a little further and says this, that if you're leaving a pre-recorded message and you've already been warned that someone has told you not to leave the message, that it's not them, do not call, they say that's still a call that falls within the purview of this exemption because it's up to the FTC to decide which calls may adversely affect the privacy rights of consumers. The FCC has not done so, and they said since they have not done so, they said even calls to wrong number debtors where they've already told you to stop calling can be a call that is potentially exempted. Now, I'm not saying, of course, go to that link. If someone tells you not to call and they tell you to stop calling or don't leave pre-recorded messages, please absolutely do so. So that's very critical to adhere the request of someone who's telling you do not call me, even if you think they're lying. It's just a safer and more compliant approach. Next, established business relationship exemption. Many of you have heard about it. It's a very complicated exemption. Most courts didn't even know how to apply it to the debt collectors. It was really an exemption that we were borrowing from for landline pre-recorded message calls to landlines, and we were borrowing it from the telemarketing side of the TCPA. But it's going by the wayside. The FCC has taken that away, or is going to, as of October 16, 2003, so the EBR doesn't apply. But most of these courts are all relying on the commercial call exemption when you make a call to a landline with a pre-recorded message without consent. Look at the bottom of your screen at page 9. Some recent decisions came out, and they are absolutely crazy. We love them on the defense side, but they're sort of out there. So this first one, Clayton, says this. They looked at text message calls to cell phones, which is completely different than the landline side of calls, and they applied that 64.1200 exemption you see there. That's that commercial call exemption, and they applied that landline exemption to a text message call to a cell phone. Most everybody, even on the defense side, agree that is a wrong decision. Yes, it's a great decision. We love it, but it's probably not going to stick, and it's not going to carry much weight because we think it was wrongly decided. Another case, also this Clayton case, every case that it cites for its position, the Meadows, Santino, Fernasiak, all those cases are pre-recorded message calls to landlines, and it talks about the exemptions therein, so they were even citing the wrong cases, but boy, somehow they got away with it in that case, and I don't know how. Let's look at the next one, Roy versus Dell at the bottom of the screen there. That case basically mistakenly applies the exemption for calls to residences again to cell phones and gets away with it. Plaintiff basically had a 1-800 business line, and the court applied the exemption to call to residences and says, and it said that debt collection calls to consumers are exempt. Great decision again. I just don't know if it's going to stick and it's realistic. Let's go to the next case, very dangerous case that's out there called Lynn versus Monarch. The reason why this is dangerous is this is talking about a VoIP phone. In this case, the defendant made a call to the plaintiff. Plaintiff says, you called me on my VoIP phone, voice over internet protocol, sort of like a Vonage type phone, and says, I am charged for the call. So therefore, the plaintiff argues that this particular call falls under the TCPA wireless line section because it falls under that sort of loophole prong that says calling a cell phone, a wireless device, or any other device for which the called party is charged for the call. That's in the wireless device bucket of the TCPA, not the landline. Defendant argued, wait a second, court. The call that we made on this Vonage phone really emanates basically from a landline call. It has to go through a landline number. It is not a wireless number from which this emanates. Court didn't buy it and said, sorry, I'm sticking it into the cell phone bucket under that any device for which the called party is charged for the call, and I'm saying that you're subject to the rules for wireless devices. You didn't have consent, and you don't fall into any of the exemptions that would apply to landlines because they just don't apply here. Very, very dangerous decision because there's no way, and I've talked to several experts, that you can really mine what is a landline, what is a VoIP phone versus a landline. You can scrub, and there's scrubbing technology out there and cell phone identification technology that can certainly identify a landline, a cell phone, and even a number that was permanently ported from a landline to a cell phone. But you can't determine whether it's a VoIP phone. So under this court's analysis, which was very weak to tell you the truth, the decision, I think, is very poor. I think it's absolutely wrong, and there's no way to defend yourself under this type of claim. It doesn't make sense. I would hope that no other courts would follow it. It's out there, and that's the danger of it. let's move on. Let's talk about prior express consent, one of the mother loads. Again, January 4, 2008, we have the FCC giving us what they thought was a gift, and it is to some degree. So they said, look, guys, we're going to give you a gift here to the debt collection industry. In fact, when I heard the FCC speak not too long ago, they said this was the express consent gift that they gave to the debt collection industry, and it's this, that if debt collector, you're collecting on behalf of a creditor, and if your creditor got the cell phone number voluntarily from the plaintiff or the consumer or the debtor in a credit application, a loan application, or voluntarily in any regard, then we're going to say when you collect on behalf of that creditor, you have prior express consent because you step into the shoes of the creditor. It's as if the creditor itself made the call. For this consent to this type of consent, what I call the pass-through consent, meaning you as a debt collector, you're not really getting it yourself, you're just relying on what your creditor has. That's called, I call that the pass-through consent. For it to apply, consent has to be given directly to the creditor in that situation. Can it be provided directly to the debt collector? Of course. A consumer, a debtor can give you consent. Tell me, call me on this number anytime. Of course, that's consent. Next. Can consent be verbal? Absolutely. Can it be in writing? Absolutely. And the courts really haven't completely ruled on whether it has to be verbal or in writing. We're going to discuss some very weird nuances. Yes, you can actually get consent for a website as long as you have the right criteria and it's clear and fairly conspicuous. Consent has to be given by the consumer. Don't rely on a relative. Don't rely on a friend. Can it be given by the spouse? Can a spouse of someone give it? Maybe, but that's a maybe, and you're going to get yourself in such a factual inquiry and mess, it's going to invite a lawsuit. I wouldn't rely on that for consent. When do you have to get this consent? In other words, when does this consent have to be given, let's say, to the creditor for you as the debt collector to rely upon it? The FCC said throughout its ruling that as long as the consent was provided in connection with an existing debt, somewhere in the context of it, sometime, let's say from the moment of inception through the existence of that debt, you should be good to go. Ninth Circuit decision says that as well at the bottom, the Meyer case. Some courts are literally looking at paragraph 10 of the FCC ruling, which says during the transaction that resulted in the debt, and they're taking that language literally. We have to fight against that. We have to look at all the other parts of this FCC ruling which say throughout, in connection with. So the FCC itself contradicts itself, but some courts are relying on that paragraph 10 and said, wait a second, it says you got to get this consent during the transaction that resulted in the debt. That means that inception. We disagree with that. We don't think that is a correct interpretation. And again, you just have to look through the FCC ruling to see what they themselves said. Next. Again, we already talked about the Meyer case, strong case to rely upon. It is in the Ninth Circuit, and that is a federal court of appeal decision, and that says as long as it's giving in connection with a particular debt, you are good to go. Let's talk about the next slide, please. We have this Mays decision. I know all of you heard about it. I know it's causing you all consternation. It is a problematic decision. It is right now the decision that this court made, and we'll get into the issues. It is right now, the court has agreed that the parties can request the 11th Circuit Court of Appeals to request them to take up 4 different issues on the appeal, and that's it. And let's just talk about Mays for a second. This is a situation where debtor goes into the hospital, his wife fills out the application at the hospital, patient information, and gives the debtor's cell phone information. Ultimately, one of the providers down the road in the emergency room, I think it was the radiologist, actually had a debt and then sought to collect the debt and hired Gulf to collect that debt. This court basically said this, that FCC's 2008 ruling, that ruling is improper. It's contrary to the TCPA statute itself. That ruling that gives a debt collector consent merely because the creditor has it is really implied consent. and the statute itself says express consent, and sorry, they're saying the FCC exceeded its authority. It can't contradict TCPA statute, and this court says, I can ignore that rule. The judge also said, I am going to say that this FCC ruling really only applied to the creditor debt collector circumstance, not to the medical debt context. They said nowhere do they see from reviewing all of the cases that have made decisions does this apply in that context. They're also saying even if I did apply this case in the medical debt context and I said that this FCC ruling did apply, the judge said, I still believe that, sorry, the number was given to the hospital. It was given to by the wife of the debtor who was ill and couldn't give it himself, and therefore if the hospital were collecting, okay, maybe I could stretch it that the hospital had consent and the debt collector collecting on the hospital would have had consent, but it doesn't stretch to the emergency room radiologist, and that number doesn't go that far. We think the court's decision is erroneous. Again, it's going to be certified on appeal. We don't know if the 11th Circuit will take it, but we think that they will because the issues are so critical. There's another case that just came down recently out of Colorado. It literally rejected the Mays decision, didn't go into a very deep analysis, just said, I completely disagree with the judge in that case said in their analysis. I think they got it wrong. I'm going to follow the FCC ruling and the consent provisions that the FCC provided. So this case just completely disagreed with it, didn't go into a deep analysis as to why, just said, I just disagree with Mays. I think that Mays is problematic, and it is a good thing that it is up on appeal, and I think that the 11th Circuit hopefully will make the right decision and interpret the FCC ruling in the correct manner. This judge went way too far. Next slide. In the medical debt context, one case out of Illinois, the Mitchum case, says, look, the plaintiff gave his cell phone to this orthopedic center. He got treatment there. He owed a debt directly to Midwest Orthopedics, and basically he gave his number. He gave it voluntarily, so the debt collector collecting on behalf of Midwest had consent to call on the cell phone on behalf of Midwest, and Midwest itself had as the creditor. So this court had no problem applying the FCC's consent gift, as the FCC calls it, to the medical debt context. Would this court or other courts stretch it on down the road? Let's say if there was some other provider, I think the argument could be made that everybody in the hospital are either agents or independent contractors, and it is presumed that once you're giving your number to the hospital in the context of hospital, that you're giving the number, that you agree to be called at the number, and you agree to be called by not just the hospital, but any providers who provide you services at the hospital. That's the argument, that the consent is just not limited to the hospital. Some courts may construe that very narrowly, as that Mays decision did. Next, let's talk about what isn't consent, because this is easy. It's very confusing, and the courts are all over the board, as you can see. What is consent? Where does it apply? When does it have to be given? And does it apply to the medical debt context? Does it only apply in the creditor debt collector context, more so in the retail sort of sector? The FCC had given examples in the creditor debt collector context, but they didn't literally mean to limit to that. They just used that as an example. That's my opinion, and that's, I believe, how most courts will interpret that part of the FCC ruling. What is not consent? Calling, capturing numbers on caller ID, definitely not consent. Someone tells you, do not call me on my cell phone, do not call me at this number. You have the wrong number, even if they're lying. The risk is too great. Just take it out of the system, block that number, and prevent it from it ever being called or picked up by your dialer. If you have consent to call one creditor, does that give you consent to call another? Not necessarily. You have to look to see how broad is the consent that you were given. Skip tracing, Meyer case from the 9th Circuit, very, very dangerous. That could also pave the way for a class. Plaintiff's counsel are saying, hey, you skip trace, I'll make it easy on myself. I'll use a skip trace class as my class, and that's going to be my definition of my class, and it's all numbers that you skip trace that you did not have prior express consent to call. And skip tracing, you never know if you do and you do not have consent to call the number at issue. When a creditor gives you a number, don't assume that just because you got the data from the creditor that you have prior express consent, that you have that pass-through consent, because you do not know from whence you're getting that number, and that's the key. You don't know if that number was given to you voluntarily. Was it given to the creditor voluntarily? Did they get it in an application? And can you ever prove that as the debt collector? So if you're sued by the plaintiff, and he says, you didn't have consent, you come back and you said, yes, we did. We got it from the creditor, and guess what? Under the FCC 2008 ruling, we have consent. They'll say, well, I never gave it to the creditor. Defendant or debt collector, you prove that you actually got consent, that the creditor got consent, and I gave them it voluntarily. That's a very difficult burden at times, because a lot of times you can't get as a debt collector the original data, the original credit application. It's just not accessible. So if you can't prove it, you have potential liability. Creditors also, according to the FCC ruling, they also bear responsibility, because the FCC said, hey, creditors, when a debt collector makes a call in this pass-through consent situation, it's as if you made the call yourself. So they're going to have vicarious liability. That Mays decision completely disagrees and says, you know what? Sorry, FCC, you went too far. You're trying to impose vicarious liability upon a creditor for the acts of a debt collector. The TCPA doesn't provide for vicarious liability, so you created a brand new law, and you don't have authority to do that. You can only interpret. You can't rewrite the TCPA. That is one part where this court may be right. It just depends if that court had any jurisdiction to contest this final FCC ruling, and that's one of the issues going to be challenged in Mays. It's a very complicated and complex issue. So let's go on to the burden of consent. The reason why this is so problematic is this FCC ruling says, hey, debt collectors, creditors, you've got this burden to prove consent. We're not going to foist it on the plaintiff to say they don't have consent. We're going to say you have that burden. And that's a very, very tough burden. As I said, it's very difficult to prove. And most courts throughout the country are agreeing that according to the FCC ruling, it is the debt collectors and the creditors that have the burden to establish that they had consent to make that call to the cell phone, or to leave that pre-recorded message on the cell phone, or to leave that pre-recorded message on the landline. Next. And by the way, you're seeing fewer and fewer and fewer landline cases, because plaintiffs' counsel know today that the law is so broad in that context. The exemptions are given such deference that they're really not going with the pre-recorded message calls to the landlines. You'll have one-offs here and there, but trust me, they're in the great minority today. Most every one of these cases is individual cases being brought for calling a cell phone or leaving a pre-recorded message on a cell phone without prior express consent, either in the individual context or in a class action context. Revocation of consent. This is also an issue that's a hotbed right now. Basically, the FCC and the TCPA leave it open how you can revoke. They never say it has to be in writing. They never say it has to be orally. They just said, we're going to leave that open. So most courts are interpreting that if someone tells you in writing to not call them, that's revocation. If someone tells you orally, that's revocation. Next page. Some courts are saying that, look, if you're revoking consent to call a cell phone, but you're doing it in the context of debt collection under the FDCPA, then the FDCPA cease and desist requirement applies, and therefore that revocation has to be in writing. That's a limited view with about 4 or 5 courts, mostly in the Western District of New York. I love the decisions. Most of the courts throughout the United States are not necessarily going to follow those, but certainly there are good arguments to make, and there are at least 3 or 4 courts throughout the country, maybe 5 courts, that have said that. Let's talk about another case called Gager. Gager's up on appeal. The decision should be coming out any day now, because the appeal was heard on May 13th, 2013. And that court basically said this: where the consumer or debtor gives their number voluntarily on a credit application to a creditor, a loan application, something in writing, some kind of contract, some kind of agreement, well then, sorry, they're bound. They can't just say, oh, okay, I changed my mind. They just can't say, oh, I orally revoke, because they're bound because it's a contractual agreement. You just can't change the terms willy-nilly. You're in a contractual situation. It's a great case, a great argument. It is from a judge who literally hates the TCPA, and I applaud him for that. He realized the insanity of the TCPA, and he's gone on to make some other decisions that are a little out there, but I applaud him for taking these bold leaps, and maybe some of them will stick. I don't know if this one will, because again, the FCC, the TCPA, they've been silent on whether it has to be revocation orally or in writing. I would say always honor revocation orally or in writing. You just don't know the way the courts are going to come down. I don't know the way the Third Circuit Court of Appeals is going to decide this Geiger decision. And there are some other cases, as you can see on slide 19, that have followed that, but not all are going to follow that. So it remains to be seen what the Third Circuit says. And then, will other circuits throughout the United States, if the Third Circuit upholds this district court decision that says revocation in a contractual situation, in an agreement, cannot be revoked, the question is going to be whether that's going to be honored. So we're going to, and in Geiger, in short, the court said the only time that you could have revoked giving your consent is at the time you actually filled out your application. You would have had to said, here's my cell phone number, and do not ever call me on this cell phone number. But what happens if the person changes their number? Does that mean that they can't call you and say, hey, I changed my number, sorry. Nope, it's too bad, you have a new number. You gave me this old number, and I'm just going to call you on it because you can't revoke your consent or you can't change it. That doesn't even make sense. So this is an issue that's going to be hotly contested, and we'll see what happens very shortly. I think we should be getting a decision within the next 30 to 40 days. Let's talk about dialers. On the next screen, very hot topic, as you all know. We all know what a dialer is under the TCPA. Again, it's equipment that has this capacity to store or produce numbers to be called using this random or sequential number generator. Again, it is equipment, a dialer, which has the capacity to dial numbers, to store or produce numbers to be called using a random or sequential number generator. The FCC has issued its own regulation that literally mirrors the TCPA's definition of a dialer. But then we have that definition, which is sort of limited, it's sort of restrictive, it is sort of antiquated, but the FCC then comes in 2008 and says, you know what, we're going to look at this whole dialer thing and we're going to change our mind, and we're going to say this, that we think that a dialer is basically a predictive dialer. So if you're using a predictive dialer, the FCC says that's a dialer that falls within the purview of the dialer definition of the TCPA. They also said, you know what, bottom line is we're talking about equipment which has the capacity to dial numbers without human intervention. Again, the capacity to dial numbers without human intervention. That definition, which the courts have called such an expansive definition, actually I call it a rewriting of the statute, to be honest with you, is so ridiculously broad. The FCC themselves have acknowledged that, hey, I guess our statement is so broad. What does that mean today? Is that your computer? Is that your cell phone that you could program to automatically dial? What is that? There are petitions pending before the FCC that are saying, hey, FCC, you have gone too far. You have rewritten the TCPA's definition. TCPA had a definition. You can't rewrite that, but you did in this 2008 ruling, and you made it so ridiculously expansive, you're choking and killing businesses. Please do us a favor. Deem that predictive dialers can be used by businesses other than telemarketers, and that we have the right to do so, and we can use our predictive dialers, and it doesn't violate the TCPA. And also, this whole capacity to dial numbers without human intervention, you need to withdraw that pronouncement because it is so ridiculous, so overbroad. Anything in the world now is a dialer. There's just no way almost to fight the dialer definition, because what today doesn't have the capacity to dial numbers without human intervention. Next. Good decision out of the Ninth Circuit. Very, very strong. Satterfield decision. Satterfield said, hey, we see what the FCC ruling said, but guess what? The TCPA's definition of what a dialer is, the the equipment which has the capacity to store or produce numbers to be called using that random or sequential number generator. That's a definition by Congress. Once they define something, you do not look to regulatory definitions. You don't look to the FCC. You don't look anywhere else. You got to stop at the statute. That's the legal argument. Statute says what it says. It defines it. You stop there and you do not move forward. End of story. It's a very good decision. It is still good law. Yes, I know some of you are saying, well, what about this Meyer Ninth Circuit decision, which came out 3 years later? It is such a poorly written decision, and yes, that's the Ninth Circuit for you. And that decision did talk about Satterfield, cites to Satterfield, doesn't overrule Satterfield, doesn't disagree with it, but for some reason this court takes the leap and looks at the FCC's 2008 ruling and says, oh, defendant, you're using this predictive dialer, and the FCC talks about predictive dialers, so you have a dialer that falls within the FCC's dialer definition. That decision, the Meyer decision, is convoluted. It is problematic. They said it in a unique and limited context, which is too difficult to get into in this context, but I would still say look to Satterfield, concentrate on Satterfield, because that's the better pronouncement of this decision. It is still good law. It is not overruled. There are ways to distinguish the Meyer decision. And then if you go to the very next decision, this is a decision, again, well, this one is out of the Southern District of California, and this is from a judge in a multi-district litigation case. So a judge that is handling, let's say, multiple class actions from all over the country in one consolidated case. And that court looked at this and said, I don't care that the FCC said a predictive dialer is a dialer. That's not what they meant. You can't say a predictive dialer is a dialer willy-nilly. They said that what the FCC is saying is basically that is technology that could fall into the purview of the TCPA, but it's got to meet the TCPA's definition. In other words, okay, if the FCC is saying that a predictive dialer is technology that could fall into the purview of the TCPA's dialer definition, it still has to meet the definition of a dialer under the TCPA, meaning this court is saying a predictive dialer still has to be equipment which has the capacity to store or produce numbers to be called using a random or sequential number generator. And I can tell you the plaintiff's counsel is saying, okay, even if we disagree with you, but even if you are right, we're going to say that all that the dialer has to do then is to store or produce numbers. And we are arguing, no, that's not what the statute says. The statute says store or produce numbers to be called using a random or sequential number generator. That language is critical. You can't just take parts of the statute and decide what part you want, what part you don't want. You've got to look at the entirety in a context, and literally you can't divorce the words store or produce from that phrase using a random or sequential number generator. You just can't ignore that language. So I think in a very, very strict interpretation, if courts were going to follow and agree with what this Midland credit case said, then what you have to do, then you look at your predictive dialer and say, hey, is this a dialer that can store or produce numbers using a random or sequential number generator? I bet you 98% of you who have predictive dialers do not have dialers that have random or sequential number generator programs. And that's the key. That's the fight that you have to make. It's a very technical fight. I understand that this discussion is very technical, but that's the fight that has to be made, because those FCC 2008 pronouncements of predictive dialers and anything that can dial without human intervention is so overly broad. And if courts, quote, some courts are agreeing with that, like this Griffith case on the next screen. Griffith, and it's not the only one. There's many other cases that say, hey, the FCC is saying a predictive dialer is a dialer, end of story. That's a dangerous pronouncement, and that's the issue that has to be fought. I understand that in all jurisdictions you can't fight that issue. I understand that the Ninth Circuit governs about 8 or 9 states in the western hemisphere of the United States, and courts in Illinois have already said, we disagree with Satterfield, or we're not going to follow it. We think that the FCC's rule is controlling here. I understand that. but the fight still has to be made. I'm making this fight every day in multiple class actions because we can't just roll over because the liability is extraordinary, and this just means this is just legal extortion. And the FCC has really done the entire country. It's not just the debt collection industry. It's the entire country a disservice. I've met with the FCC in person. I've had this talk to their face. I told them that they're killing businesses, sending them overseas because of this dialer ban, and that they literally rewrote the statute, had no authority to do so. They're ready to listen. They're ready to look at a petition that does the right thing. They just don't think they have that petition before them right now because they're afraid of what is called unintended consequences by virtue of the petitions that are before them right now, and that's the problem. Let's move forward. Let's talk about preview dialing. Next screen. I know you're all talking about preview dialing. Well, wait a second. If I dial in this preview mode, does that get me out of this FCC ridiculous ruling? Does that get me out of the predictive dialer issue, or at least the issue that is capacity to dial without human intervention? Does that at least take my dialer out of that purview? This is the problem. Next slide. That you know that this decision called Santander came out. Yes, that decision has been vacated. It's no longer on the books. That's a great thing. But its reasoning could be adopted by other courts, meaning other courts could just follow the same or similar reasoning on their own without even resorting to what Santander did because they can't cite to Santander anymore. But Santander said, I see that you're dialing in preview mode, which means that before a number is ever dialed by your dialer, that number or the account pops up on the agent's or the collector's screen, and before that number can be dialed by the dialer, it's the collector who makes the decision to dial it either by clicking on a mouse or pressing a keypad on the keyboard. He said, well, okay, we understand what you're doing, but basically, let's look at your dialer that it's going through. Does that dialer still have the capacity to dial without human intervention, or is your dialer basically still a predictive dialer? I don't care that Santander Court said that you're using preview mode at this given instance. You're still going through a dialer that has this capacity, and unfortunately the court said capacity is the key. Capacity is a word that was used in the TCPA dialer definition itself. The FCC also picked up that when they said capacity to dial without human intervention. So that's the danger. In other words, they're going to look behind the man behind the curtain there. And they're going to say, all right, so you used it in preview mode, but you're still going through this dialer. So the question is this. If you're using a dialer that has been completely reconfigured so that it no longer literally has this capacity, quote, to dial without human intervention, it no longer has a predictive dial capacity, do you now have a dialer that doesn't fall into the purview of the TCPA because it literally requires human intervention because you have now configured it so when that agent pops it on the screen and clicks, that's the only way that dial could ever dial. It can never even on its own dial in a different way. Also, would that dialer still meet the statutory definition of a dialer? Would it be equipment that has the capacity to store or produce numbers to be called using a random or sequential number generator? If it's configured right, the answer to that should hopefully be no. It doesn't mean that these are absolute givens, and this absolutely takes you out of the purview of the TCPA, because the dialer definition itself there is a lack of interpretation throughout the United States on what that dialer definition itself means, and there's still fights out there. But at least it gives you a fighting chance to make arguments. We need to make a level playing field, and that's what I've been advocating throughout the country. We've got to have a level playing field so we have something in the defense side to argue. Let's talk next about wrong number calls. I know, I just keep on giving you more and more things that plague you, and I can't stand it myself. I talked to the FCC about wrong number calls, telling them, okay, we've got the Soffit 7th Circuit decision which says you called someone who you didn't mean to call. You got the number voluntarily from your creditor, or you got it directly yourself, but somehow over the time that number was reassigned to a new person who was not your debtor, who was not your consumer, and you call that number and you dial that number, and the person says, sorry, I never had any business dealings with you or any debt with you. I never gave you consent. Now I'm suing you. And then the person winds up suing, let's say, in a class action. The 7th Circuit said that person has standing to sue. they're any called party under the statute, and the statute says any called party, and basically they are. Other courts have said it is the subscriber that has standing. Other courts have said it's the regular user of the telephone who's called. If they're called and they don't have any, they never gave consent, they have standing to sue. Next slide. Various cases right now up on appeal. The Breslow case. It was just heard on appeal on July 16th, 2013. And that case on appeal is arguing this, that if we're calling an unintended recipient, there should be no liability under the TCPA because we cannot gauge our liability. There's no way to do it because of the number that we got consent for. And if we followed our job under the TCPA and we got consent and everything should be fine, if we follow the law, we are now still potentially liable under the law, even though we're following it to the strict letter of law. We're getting consent from the horse's mouth, from the debtor, and somehow it gets reassigned a week, 2 weeks, 3 weeks, a month later. How are we ever going to know that? How would you ever figure that out? You can't scrub for it. You can scrub to identify cell phones, but you can't scrub to know when it was reassigned, on what moment, at what hour. It's unrealistic to have wrong number calls as potential liability under the TCPA. We hope this Breslow case, which is pending before the 11th Circuit Court of Appeal, which basically governs Florida, Georgia, and I believe Alabama, we're going to see how they're going to come down on this. It was a very conservative panel of judges that heard that. We pray that they are going to see logic and reason here and the insanity of wrong number calls giving rise to potential liability under the TCPA. Next. I'm sorry, I'm just going to step back for a second. There's this Papa John's case, and I don't want to belabor it. That is a case that certified a TCPA text message class, and it found statutory standing for even the unintended recipients. In other words, Papa John said, we didn't mean to call all these people, and they're not consumers or debtors or people who we meant to call or people who signed up to get information from us. And they said, sorry, those persons that you didn't mean to call, that you didn't have any relationship with, and that did not give you consent, those unintended recipients have standing to bring a suit. And that case has been, I believe, settled for somewhere in the 11 to 15 million range when all is said and done, $15 million. Again, that's the insanity of these TCPA class actions. They are literally cash cows for the plaintiff's bar. Next. This next slide really applies to the teleservices industry. I want to make clear that the new FCC October 16, 2000 rules are for telemarketers. The FCC said this does not apply to any other industry. With respect to all other industry, the old rules apply, the old consent rules, which are you can get consent orally or you can get it in writing and you're good to go. The new FCC October 16th rules say for teleservices industry, for sales, for telemarketing, prior express consent when you're calling via a dialer to a cell phone or leaving a pre-recorded message on a cell phone, or if you're leaving a pre-recorded message on a landline, you have to have prior written express consent. That is a crazy ruling. It is absolutely draconian. I understand how telemarketers are saying to me, how in the world can we comply? The FCC said, we're going to allow something called e-sign, and we're going to allow this ability to capture written consent via a myriad of ways. You can get it on your website. You can get it via capturing it on your phone system, as long as you leave the correct disclosures. You can get it orally, so long as you give the correct disclosures and then you capture it on your phone system. It is very draconian. It is very difficult. There are ways around it, but it is a problem for the telemarketing industry, and many are recognizing that even though the FCC said, oh, don't worry about the written consent requirement, telemarketers. We know it's draconian, but you can get consent via this e-sign, and e-sign is pretty broad, and this electronic signature way of getting consent allows you to capture it in various different ways. It is still very, very, very difficult. So, again, the FCC is going to maintain its prior express consent standard for the rest of the other industries, not the collection industry, any other industry other than the teleservices industry. Let's move on to compliance issues. We've talked about some of them during this conference. The most important thing right now, because the law is so in flux, it is so problematic. Yes, there are fights and defenses to be made, but sometimes those defenses are a bet the bank or a bet the farm argument. In other words, you could take a risk on class certification that you may win the dialer argument. You may win the consent argument. You may win that there's so many individual inquiries on the issue of consent that these courts can't certify. But if you lose the potential liability for calls made over numerous years, and it's a 4-year statute of limitations, at least in most states, you're looking at millions or hundreds of thousands of calls. That's liability in the hundreds of millions to the billions. It's ridiculous. It is at times a march to the settlement conference room because you don't have a choice, especially in class action litigation. So for now, we're saying use your cell phone ID technology to scrub your cell phones. Segregate your cell phones from your landlines. Do not call those cell phones until you know you have prior express consent, until you absolutely know the creditor from whom you are receiving phone numbers absolutely had prior express consent. Make sure that you're using cell phone identification technology that is also scrubbing the ported number list so that you know what numbers are ported. There is a ported number exemption, but it is only a 15-day grace period. So if a landline was ported today to a cell phone, you need to scrub your numbers against that ported number list as well, so you'll know, because you only have a 15-day grace period to still call that cell phone without consent until they say, sorry, the 15-day grace period is over, you have scrubbing technology, you should have known the number was ported. Try to get representations from your clients to put express consent in all of their applications, their information, all of their loan applications, etc., anything, the credit card applications, anything they can do to capture express consent. Get broad consent language that also includes talk about automatic telephone dialing systems, pre-recorded voices. That's very critical. Don't capture anything on your ANI devices, your caller ID devices. If you capture, never load them into a field that allows the dialer to pick it up. It's just a recipe for a lawsuit or a class action. Next, remember, manually dialed calls, and I'm literally meaning manually, I'm talking about a PBX dialing a cell phone number, that does not violate the law. Picking up the PBX that I'm talking to you on, that you all are probably listening to me on, and dialing the 10 digits, it does not violate the TCPA. It's only using dialing devices or leaving those pre-recorded or artificial messages. Remember about preview dialing. It is, be very careful with it. Be very careful how you're using it. I know a lot of people are using it. A lot of industries are right now, and thousands of companies, but it is not an absolute end-all and be-all. And plaintiffs' counsel are getting wind now of the preview dialing. They know about the Santander decision, and they are just poised to poke holes through this preview dialing issue because they're finding that the dialer that you're going through still has the capacity to either dial without human intervention under the FCC ruling, or maybe still has some capacity under the TCPA's definition of a dialer. Train your collectors. Train them to get the proper express consent. Create phone fields so that your collectors can put in a number that is a cell phone number with consent, a cell phone number without consent, so that your dialer can never pick up the number that's without consent. Also, make sure that your collectors are putting in notes. Got consent to call and put the name of the number down. Document it. Documentation is going to help you at least try to defeat these cases, especially on an individual basis. Always be able to distinguish your numbers from skip trace numbers, from ANI numbers. Make sure that you have those ANI and skip trace in a separate phone field that can never be picked up by your dialers. Talk to your IT people. Make sure that your dialers do not have the random or sequential number generator programs that are in the pure definition of the TCPA's dialer definition. Also, look at your filings. Look at your SEC filings, your websites, your whatever you're saying in there, what you're telling the world. You wouldn't believe what plaintiffs' counsel can find on your websites, and that they're using those words, your language, as basis as the springboard, not only for TCPA cases, but for FDCPA cases, FDCPA class cases, and FCRA cases, et cetera, et cetera. Make sure you don't have any language that talks about auto dialers, predictive dialers, that we use this, that we have the fastest dialer in the country. Don't use that language. I know why you use it, but don't use it because, unfortunately, they pick up with that language, and plaintiffs' counsel say, hey, they've already admitted that they have a dialer that falls into the purview of the TCPA. Look at what they're saying, and they're representing to the world. I know I've given you so much information in a very short time. I know we didn't have much time for questions. Unfortunately, on my my little queue here, I can't even see the questions that may have been posed, so I'm sorry I can't even answer them. And unfortunately, because I have another matter, and I believe 2 minutes or so here, I need to end this call. I want to thank all of you. I know this was very, very quick. Ryan, I've got literally 1 minute left, so if there is one question that you could pick up that maybe I did not answer, that we could at least answer before I hang up, I would be glad to do so.
And as a note, while Ryan is doing this, this is Tom Moore again. David, thank you very much. Fantastic. You covered a lot of ground in a short period of time, so you're commended on doing so. For everyone on the bridge, all the questions that have been posted, we will go ahead and work with David to have those questions answered and sent to all of you, all the webinar registrants. We'll send those out. So, David, thank you again. I know you're on your way, and we'll follow up with you later. And then, Ryan, I don't know if you want to, thanks again, David. And then, Ryan, I don't know if you wanted to open it up. We had scheduled this for 90 minutes. If anyone had any questions in reference to the work that Content Center Compliance, Interactive Intelligence, or Avtex does, we can certainly answer those here. If not, we can conclude the webinar and, again, follow up with any questions that people have posted.
And thank you. This is David Kaminski. Thanks again to everybody for bearing with us on this truncated or shortened presentation, but we've really given you the meat of everything. I know we had to do it very quickly. Hopefully you're able to digest it, and I believe I've given you a lot of information in the PowerPoint itself so you can review what we discussed, and it should be able to clarify some of the issues. Thank you all. Be well, and we'll speak soon.
Thanks again, David. Yeah, and this webinar will be posted. Ryan will send out a link to this webinar that will be on his YouTube account. So any individual that would like to go back and review, they can certainly do so with that link. Well, with that, Ryan, did you have anything to add or conclude at this point? I don't know if he's muted here.
Can you hear me? Sorry about that.
Oh, yeah, now we can hear you. You must be muted.
I had the phone on mute there for a couple minutes. Yeah, so our YouTube channel is just our company name, Contact Center Compliance, and we will definitely get out the slides and the webinar presentation link to the YouTube channel next 24 hours. If anybody's looking for wireless scrubbing, identification, complying with the TCPA as far as data compliance, we can definitely help people out. And anybody that came to the webinar was definitely open to doing a free trial, kind of help you guys analyze how many cell phone numbers you might have on your database. It's a hotbed of litigation. It's probably the bulk of our business in the last 90 days. Is just strictly about people getting set up for scrubbing. We have an integration into Interactive Intelligence and into their dialer product, along with the several other vendors that are out there. So we have lots of ways that you can connect in. There were a lot of questions on the webinar, and
there were. Okay, good.
So what I thought I would do is, since we still have, a couple hundred people here on the call, is just try to go through at least a couple basic ones that hopefully can clarify things for everybody that's kind of sitting here like, wow, there's a lot out there. I mean, even being in the business and, seeing what's required, the case law aspect is a little dizzying. But there's some real practical things. I think there's some questions on here that we could probably try to answer for folks, just to give them an idea of maybe where all this lies. Kind of more FAQ questions, and then the more legal questions, I definitely think we should get David's insight. We'll follow up with people individually. There were some rather lengthy ones, but if people want to hang out and go through a couple of these.
Sure. Yeah, let's do that.
So first question, which kind of was the first comment a minute we were making, was about the slides. Yes, we'll get those out, and we'll get the recording out. But as far as also additional resources, people are like, well, where do you seem to be like wanting to know where they can get additional information? Are we going to do other webinars? Are we going to go back and go through these on another call? I am looking at trying to do another webinar in the next 3 to 4 weeks, and as we get closer to that deadline of the October 16th FTC, the TCPA changes, then there's going to be a couple more sessions that we're going to do, and as we get closer to there. So let me go through a couple of these. One of the questions was if people can get consent via text message in terms of to kind of override a a wireless status. And I've heard this question from before from a couple of my clients, and kind of what David was saying was the burden of proof is on the burden of the seller or the marketer. So you might be able to get it that way, but are you able to? Is it going to qualify as express written consent? I don't know that a text message would be enough. So you probably want to run that language through an attorney and see what that looks like. But I don't think that a text message qualifies, and it's a little dangerous too, because there's just so much litigation and so many easy ways that you can be targeted by a lot of these individual plaintiffs and folks looking to just, like David said, they'll go to your website and find evidence against you any way they can. It's a lot easier now through web searches, other things to get that information. So and the one big point that, as far as texts go, that I think get a lot of confusion on is whether text messages, are they treated the same as kind of a basic TCPA question as calls, which they are. TCPA covers text as well as calls. Email regulations are covered under CAN spam, and so that is slightly different in the sense of the texting falls right underneath the same platform. There's another couple in here that are worthwhile.
This is Tom again. While you're looking at a couple other questions, I just wanted to make note for those individuals attending this webinar. If you're an Interactive Intelligence CIC customer, Interactive Intelligence has recently come out with the TCPA client or application that sits on top of your CIC system, and it allows you to meet the new or the current compliance laws surrounding dialer. So we can certainly talk to you and have a follow-up conversation with you if you'd like to see how that application works, how it integrates into your CIC system. So anyway, for those individuals that would be interested, we can certainly talk about that at a future date.
Tom, that's a good segue into the questions I was going to ask, which is about manual calls. So let's say you take away the dialer, you put something into place where you have human intervention. What compliance issues exist, and what does TCPA apply? So remove that part and TCPA doesn't apply, there is one area that I was going to mention, which is some of the state rules. We're really talking FCC here, but there are about 5 states where there's restrictions even on a manual call to a cell phone. And then, but in essence, you do remove a lot of the headaches around wireless calling by manual calling, but there are state issues, and there's some big states in that group. You've got New Jersey, you've got Texas, Arizona, Louisiana, and the 5th one is Wyoming. So even in any wireless, any call to a wireless number in those states, even if it's not a dialer, it's the interactive platform, it's whoever, somebody picking up a phone, and it ends up in a consumer, it's a sales call, technically those can be problematic. So that's one that kind of catches people by surprise.
Wow.
The other.
So you have to be careful if you're making calls into any of those states, even using manual solicitation. And
the other thing that kind of trips people up in terms of what wireless data is out there and what you can use to comply is that Neustar has the kind of exclusive contract for ported wireless tracking. So we happen to be a reseller for them so that we can apply that when you do a wireless scrub. That makes up about 5.5 million numbers of people that have ported over from landline to cell phone. And then you've got the people that actually port back to landline from cell phone, meaning they take their cell phone number and now they want to have that as a semi-permanent landline. That's about 500,000 people. But out of the whole wireless universe, that's only maybe 1% or so of the wireless numbers. The bulk of them can be identified by the wireless exchanges, and that's the source that kind of is a little more difficult to keep updated and combine on a daily basis with the Neustar updates. So it's honestly why a lot of people look to have somebody either do the scrubbing for them or have somebody else provide them consolidated data, which we happen to do. We'll either push the data to a client, we provide the scrub solutions or ways to do that on a daily basis. And you only have that short window of the 15 days on the update periods of how often you need to scrub. So that's as far out as you can go. And so it gets a little tricky with the daily updates and making sure that that's all dialed in. And the big difference with wireless enforcement, it's not like you have to wait really for the FTC to come after you all day they could. It's the private litigants, all these cases that are, they're looking for easy ways to get classes together, file suits. But the FCC fine is actually much higher. I mean, they can technically come after you for like $16,000 per call or per violation. So either way you look at it. There's also a lot of cases, run into several in Florida with marketers who have been sued by Verizon themselves. So they've got campaigns going. They're hitting people on Verizon's network. Verizon's consumers complain. Verizon will take action against the marketer themselves. So you've got a lot of different angles that are coming out. So it's definitely difficult to try to track all that. And then tracking your express consent, like Dave was saying, you got to be able to prove that and store it, maintain it, and then make sure it's from the kind of first party. It can't be transferred. And the disclosure piece, the one question we were getting on here is about what needs to be in the express consent. I think on a previous webinar or somewhere we have some bullets on that, and it's pretty apparent to the consumer that they're, signing up for the October 16th piece. They have to show that they're opting in to receive automated calls, and it's fairly lengthy in terms of disclosure. So you can't really, they don't make it so you can just stick it on a website or anything like that. It's not something that a lot of consumers, I think, are really just going to go for right out of the bat. So definitely a little bit of a challenge. VoIP and landline, the other question. So you have about 300 million cell phone numbers in the U.S. The VoIP numbers are a little tricky. The carriers themselves don't readily provide their footprints, if you will, and they buy and lease numbers all the time. So the VoIP case that David was talking about, where he was talking about that, that there's no way to really comply with that aspect. He's right. There's technically not like a source like Newstar, or in the case of the do not call list or anything, you can't go like get that data readily. But we have a source where we can run some files for VoIP scrubbing. We've done a couple tests, and there's, we're running up against about 15, 20 million numbers that are known VoIP numbers. That's probably not all of them, but the best source we've been able to identify, because we've had some clients that have wanted to take extra step, make sure they're not going to get in the line of fire by calling a VoIP number on that end. So somebody had a question about that aspect. There's also the public service do not call list that's coming out sometime in the imminent future. They signed it into law with the Middle Tax Class Reform Act. Basically requires the publishing of numbers like hospitals, emergency rooms, for protection of kind of homeland security, so that these numbers don't get jammed by marketers. As far as I know, most marketers or most clients of ours don't want to call these numbers anyway, so it's not like a huge problem, but there's a risk of publishing those numbers, so the government and the FCC is trying to figure out a way to do that, but it is actually technically supposed to take place. Somebody was asking about exemptions for HIPAA under the FCC requirements. I think there are some exemptions for some HIPAA-related calls and informational type calls specific to FCC, but that's one we'll have to have David weigh in a little bit on. I'm not a HIPAA expert, but I know that there are some exemptions out there, depending on whether you're debt collection, you're doing telemarketing calls. The one type of calls that the FCC does have jurisdiction over is political calls, which surprises most people, that even on an auto-dial political call, you still cannot call a cell phone number for the most part unless you've got meet that express consent requirement. So you might start getting some calls around election time that shouldn't get too many on your cell phone. So we'll see. A lot of questions about opt-in and what needs to be in the policy and what it needs to look like, how it needs to be laid out. That's not been tested in terms of a lot of the new changing laws and what needs to be in there, what's going to stand up. But like I said, I think David's got some bullets on those that we can share with everybody. So let's see. I'm looking to see if there's anyone else that's kind of FAQ style. I think the rest are really kind of geared more for offline conversation, since they're fairly in-depth and may require a little bit of an opinion. And I think the one thing I'll add is, companies in most cases want to comply with the law and be conservative, but a lot of the application of these rules, some of it depends on how risk adverse you are, and versus, are you going to go to a system where you just disconnect your dialer and then put together a preview dialer system and then separate them there, or to call cell phones, or are you going to just have a completely manual key press old school phone room, which I don't think a lot of companies want to go to. How are you gonna make sure that complies? And then the loss of the EBR is being a big factor. The one that I think the FCC kind of snuck in there as far as cell phone contact on a dialer, the the prior express consent versus the written consent. That's the one that I think is just still one that doesn't seem like it's going to change either, that there is not a proposal on the table that they feel comfortable with, that they want to stick their heads out of the sand and say, yeah, we're all going to endorse this. It's all kind of like, it seems like they kind of get that there may be some changes that need to be made, but until they see a good proposal. So I know that there's some organizations out there trying to make some things happen with the ACA and PACE and others. So those are good places. I think they've all got kind of regulatory type events coming up that help as far as lobbying, and they can help steer you towards people that might have some influence, especially with the FCC. Tom, do you want to add anything else?
No, I think I'm good. Great job in going through those questions, and we'll just work with David to get the ones that are more specific answered and posted. No, I'm good with everything. I think we had a really good attendance. David was amazing in getting through all the information. I want to thank everyone that joined us, and keep your eyes open for an upcoming event. To Ryan's earlier point, we'll probably put something together in the next couple of weeks here before the October deadline, and we'll go from there. So Ryan, thanks again for setting this up and getting us in front of, or getting David in front of us, and we appreciate the help.
Great. Appreciate everybody's time. If anybody needs to get a hold of me, my contact, I'll put everybody's contact information on the follow-up. I'm easy to find out at dnc.com, and just my first name at dnc.com. Like I said, we'll get some follow-ups out to everybody, and wish everybody luck with the implementation of the TCPA.
Very good.
Thanks.
Yep, and that goes through to with me as well. You need to get a hold of me. It's Tmoore, T-M-O-O-R-E, at Avtex, A-V-T-E-X, avtex.com. We work with all types of customers, really helping them stay in compliance, certainly within their contact centers, and then bringing in all the other areas of expertise that I mentioned before, which would be the portal technology, unified communications, contact centers, and CRM. So, but everyone, thank you again for attending. Ryan, thank you, and we'll talk to everyone soon. Take care.
Take care.